let's return to where we left off in discussing agreement and consideration in contracts. So just to review for a second, we talked about that there's four main elements of a contract. One is that you got to have agreement. The second is that you've got to have consideration, something of value exchanged between the parties to a contract. You've got to have capacity. Both parties to a contract have to have the capacity to enter into the contract. And then the last one is legality. It has to be for a legal purpose. So those are the four main elements. This week only tackles the first two elements, agreement and consideration. Most of the lecture on Tuesday was an overview of contract law, and then we got into the different parts of the element of agreement. Today's lecture is going to be getting into the different parts of the element of consideration. So that's where we sit today, and then we're going to talk about the cases that you have hopefully read for this morning. So that is where we are. So consideration, again, is just that there's a value given in return for a promise. Each side is giving up something of value or performing an act of value, or they're refraining from doing something that would otherwise have value to them. We break down the element of consideration into two smaller elements. One is legally sufficient value, and the other is a bargain for exchange. So legally sufficient value, what that means is that the promise, the consideration given, can't just be nominal. You have to actually be giving up something. So for example, there would not be legally sufficient value in promising to do something that you're already bound to do. I'm contractually bound to teach this class for CSU this semester. So I can't go into the dean and say, I will continue teaching this class if you pay me an extra $5,000. I'm already bound to do it. I haven't given up consideration. If she says, yes, we'll do that. I haven't given up anything because I'm already bound to do that. The law doesn't get into, though, ruling or deciding on whether you made a bad deal. So if I wanted to sell Miss Alderman my Porsche that I sold several times to you guys on Tuesday, if I want to sell her my Porsche and I'm desperate for money and I sell her a $20,000 car for $5,000 and later on I regret that, I can't go back and say, well, there's no consideration because $5,000 wasn't a legally sufficient value. That's not what we mean when we talk about that. We're not getting into whether or not the deal was fair. Legally sufficient value just means that each side has to be giving up something. And it has to be something that they're not already bound to do or they're not otherwise obligated to undertake. Consideration can also be not doing something. I'll pay you this much money, but you can't. Or CSU says, as part of your teaching contract, we'll pay you an extra $1,000, but you can't teach anywhere else. So I couldn't moonlight over at Columbus Tech or Troy University or some of these other schools around. I have the right legally to go and moonlight and teach anywhere else I want. But that would be consideration on my part because I'm giving up the right to do something. So sometimes in law or contracts, we think about consideration being that everybody's got to do something. Well, you could have legally sufficient value in not doing something as well. So the bargain for exchange. One promise has to induce the promise on the other side and vice versa. Whatever the deal is, whatever the subject matter is of the contract, it needs to be bargained for. And this distinguishes contracts from gifts. If I want to give Miss Alderman $50, that's just a gift. That's not a bargain for exchange because she didn't give me anything in return. So that kind of differentiates a contract for a gift. If she offered to grade papers for me, and I give her $50. Now we've got a bargain for exchange. She's giving up something and I'm giving up something. And so my giving her $50 is not a gift. So those are kind of the breakdown elements of consideration. There's not a limitation that says what consideration can or can't be. There's not a list of things that we could go, or a checklist that we could go down to say, well, is this consideration? Is this consideration? Is this promise giving up something? It's always going to be a case-by-case basis. But the two main things to remember, again, are it needs to be a bargain for exchange. Each party has to give up something, do something, no gifts, and there has to be some legally sufficient value, meaning you can't be promising to do something that you're already bound legally to do. Adequacy of consideration, and I think I already got to this, but that refers to the fairness of the bargain, and courts, as I said, don't evaluate the fairness of the bargain. They just don't get into that. Our society gives individuals the freedom to make whatever kind of contracts and deals and bargains that they want to make. The court doesn't, we don't have a backstop, or we don't have a protection from the court in getting us out of deals that we regret later on. There are times when a court might look at the deal and say, okay, there was something unfair about this deal. Somebody was under duress. Somebody, there was undue influence, or there was fraud. In those cases, the court might say, okay, it was inadequate consideration. So I just said two things that are a little bit conflicting, so let me make sure I'm clear on that. Generally, courts will not evaluate the fairness of a bargain, the fairness of a contract. They will not get into whether or not you made a good deal or a bad deal. But if a court sees an element or a whiff or some evidence of fraud, or where somebody had undue influence over the other person, or the person was under duress, then the court might step in and say that consideration was inadequate. But generally, just regret, buyer's remorse, I made a bad deal, I wish I'd have gotten more. The courts are not going to get involved in that. There are, when we look at whether or not there was consideration, I want to give you some specific examples of agreements that don't have consideration. So one is pre-existing duty. I've kind of already alluded to this a little bit, but under most circumstances, if I make a promise to do something that I'm already legally bound to do, that's not consideration. There are a couple of exceptions to that, and I know this must drive y'all crazy when I give you general rules and then we go right into the exceptions. But for example, let's say that a party to a contract runs into some unforeseen and substantial difficulties that they couldn't have anticipated at the time that they made the contract. In those situations, the parties might agree to give extra compensation. So an easy example of this is a construction contract. CSU contracts with my construction company to build a new building on campus. We enter into a contract. They're going to pay me $5 million to build this nice new business school building. That's a good price. Everybody's happy with that. Well, once we get into the construction, we find that there's an Indian graveyard buried below, or some geological issues that nobody could have anticipated, and now the cost has gone up by another couple million. So we redo our contract and say, look, I know I said I'd do it for $5 million, but now I'm going to need $7 million to do it because of these unforeseen difficulties. And CSU says, that's fine, we understand, we're willing to do that. So we do a new contract. So earlier I told you that would not be consideration on my part because I'm doing something, building the building that I was already contractually obligated to do. And so CSU could use that. Well, if they tried to use the idea that I didn't provide consideration on the new contract, then my defense would be unforeseen difficulties, unforeseen circumstances. So in those situations, you might be able to tear up the contract and start again. But in my example where I just go to Dean Kidder and say, I just don't really feel like finishing out the semester, but if you give me an extra $2,000, I'll do it. And she agrees to that, then in that situation, she might be able to get out of that by saying that there's no consideration because I already had a pre-existing duty. Does that make sense? One of the most important things in contract law, and that we're going to go over in 2 weeks when we finish all this, and maybe a little bit today, is that this area of law is not black and white at all. So a lot of the fact patterns that I give you, I want you to be able to think through and look at all sides of them and maybe even argue it both ways. Well, okay, let's see. This fact pattern deals with consideration. And I know that you have to have legally sufficient value. So this person, they've redone a contract, and now Tom is promising to do something that he was already legally obligated to do. That's not legally sufficient value, but hold on, I know that in some circumstances he could do that. So I just want you to be able to think through all of the different things that we talk about as you evaluate these things. This is not like contract law is not a math problem where 2 + 2 always equals 4. There are going to be different circumstances and different ways to apply all these general principles that we're talking about to specific facts. Past consideration is not cannot provide consideration in a future contract. So if Mr. Thomas gives me a ride home from class today, and then next week he says, I say I'll give you $5 for that ride home last week, and he says deal, and I don't pay him and he sues me, there's no consideration for past acts. That wouldn't count. And the reason for that is there was no bargain for exchange between me and Mr. Thomas at the time that he gave me a ride home. You can't do it later on. Another area when there is no consideration present is illusory promises. And these are promises that just lack enough detail or definition for us to really determine what the terms of the bargain are. Remember when we were talking about the element of agreement, the agreement had to be reasonably definite. We had to be able to look at the terms, and reasonable people could agree on what the terms were, what was expected, what it was we contracted for. Well, kind of the same thing with an illusory promise. So if I told my employees at work, I'm going to give you a bonus at the end of the year if we have a good year. Well, what is a good year? Right? That's pretty hard to determine from an objective standpoint. We all have different ideas of what would be a good year. I mean, a good year in COVID is going to look a lot different than a good year in a non-COVID year. That's an illusory promise. So we have to be really careful about things like that. Okay. I'm going to try not to confuse y'all with this. But there are some situations when one person or one party makes a promise to the other party, and there's no consideration coming back from the other side. For example, I tell the Boys and Girls Club that I will donate $10 million for them to build a new campus. That's really a gift, because there is no consideration coming back from their side, right? They're not doing anything for me. But I make this promise to them, and we could all agree, again, based on those facts, that this is not a contract because it wasn't bargained for. There's not legally sufficient consideration coming back from both sides. This is not a contractual agreement. This is just a gift. Well, let's say that I tell them that, and give them a pledge card, and we have a big ceremony, and we do one of those big giant checks, to the Boys and Girls Club, and my picture's in the paper, and they go out and buy a piece of land. They do all their pre-construction activities. They hire an architect. They hire construction people, and right before they start, I say, you know what? I don't think so. I've changed my mind. Not going to give you the $10 million. We didn't have a contract, but in some circumstances, the court might impose one anyway. And the reason that they might do that is that when someone makes a promise to another person and they know that that other person is going to rely on the promise, and the reliance by the other person is reasonable, then we're not going to let the person who made the promise that caused somebody to act or not act to their own detriment, we're not going to let them out of that. So that's an agreement that lacks consideration, but the court's going to impose it anyway. And this is an idea, the legal term for this is Promissory Estoppel. And that just means that once you've promised something to somebody and they relied on your promise and their reliance was reasonable and you knew that they were going to rely on your promise, then you can't get out of it. So if we look through those elements here on my gift to the Boys and Girls Club, if I am sitting at dinner one night, well, let's just say that I see the president of the Boys and Girls Club board downtown one night on a Friday night, and we're out and we're just chatting, and he's like, yeah, we're doing this capital campaign, trying to raise some money for a new building. I'm like, yeah, I could give $10 million to that. And we never say anything about it again. And he goes and hires an architect, hires a construction firm, buys a piece of land, gets ready to do construction, calls me up and is like, hey, I'm ready for you to make that $10 million payment that you said you would do. Well, in that case, we might not have something called promissory estoppel. Did I make a clear and definite promise? I'll give you $10 million for it's pretty clear. But is it reasonable for the president of the Boys and Girls Club board to think that that he should take all these other actions based on what I said in passing on a Friday night downtown? Is that reasonable? Was it reasonable for me to expect that he would rely on that? I think that I could make a pretty good argument that if you're going to take some action based on a potential $10 million gift, and the only assurance that you have that's coming your way is something somebody said in passing to you one time downtown on the street corner on a Friday night, I don't think that's reasonable reliance. I doubt that would be promissory estoppel. So again, it needs to be something that's clear and definite in terms of what the promise is. The person who makes the promise has to expect that the promisee will rely on the promise. And then the reliance has to be reasonable as well. And then, this is an important part too. The person who's relying on the promise has to actually do something to their detriment. Like engage an architect, pay for plans, buy land. If the Boys and Girls Club did those, they would have actually relied on the promise to their own detriment. If I make the promise to the Boys and Girls Club that I'll give them $10 million, we negotiate it, or I shouldn't say negotiate, we talk about it, I put it in writing, we do the big check ceremony, I'm in the paper, and I change my mind and call them up and tell them I'm not giving them $10 million, and they haven't done anything to their detriment, they haven't purchased land, they haven't engaged architects or construction firm, then promissory estoppel is likely not going to apply. Because the whole idea behind promissory estoppel is You can't lead somebody to believe that you're going to do something for them and then have them act in a way that would be to their detriment if you didn't follow through on what you're doing. That's really what this idea is. So if the Boys and Girls Club hasn't done anything that's detrimental to them, then I could get out of that promise because it truly is a gift. Does that make sense? The case that you read, the Wright versus Newman case, is a very interesting application of promissory estoppel, which we'll get to in a minute, about what exactly it is that we think that the man in the case promised and what the woman in the case relied on, and whether or not she really relied on it to her detriment. And you saw in that case how the judges disagreed about whether or not her reliance was reasonable and whether or not there was any detriment to her. So that is the idea of promissory estoppel. How is that different than quasi-contract? So remember when I gave you the example on Tuesday about the people that I'm trying to sue for not paying me, well, I shouldn't say that. That's not right. The people that I'm talking about suing so that they would pay me my legal fees, that was quasi-contract. That was the idea where we know there was never an agreement. There was no contractual relationship between these parties, but the court is going to come in at the end and impose one. They're going to find that there was an agreement to avoid unjust enrichment. I didn't have a contractual relationship with the agency, but because I did the work and they benefited from it and they knew I was doing that, even though we didn't have an agreement, my theory is the court should impose one, because to not do that would result in them being unjustly enriched. That's not the same as promissory estoppel. In promissory estoppel, we have a party that actually made a promise to the other person. So they're similar in that the court would come in on the back end, and in the case of promissory estoppel, the court would say there really wasn't consideration, but we're gonna impose promissory estoppel as a substitute for consideration. In quasi-contract, the idea was there was never a contract at all. There was never even a promise made between these parties. But the court is going to impose an agreement anyway to avoid one side being unjustly enriched. So they're similar in that the court is coming in behind and finding an element of a contract that was not there to begin with. But the difference is that promissory estoppel is a substitute for consideration, and quasi-contract is a substitute for agreement. I hope that's not too confusing to you. I'm gonna jump for just a second because there's a topic that I skipped over when we were talking about making offers that I want to make sure we make clear. So jumping back to the idea of an offer for a second. And we were talking about when can an offer be terminated. So if you'll recall Tuesday's discussion, the offeror, the person who makes the offer, can terminate the offer if it hadn't been accepted yet. Miss Alderman, would you buy my Porsche for $10,000? She doesn't answer. She hasn't accepted my offer. Then the next day I say, hey, I take my offer back. That terminates the offer. She can't then later come in and say, I accept your offer to buy your Porsche for $10,000. I've terminated it. Remember that a counteroffer is a termination of the original offer. I say, Miss Alderman, I'll sell you my Porsche for $10,000. She says, I'll give you $8,000 for it. I say no. She says, okay, then I'll give you $10,000. Too late. My offer is terminated when she made a counteroffer. So that's another way that an offer can be terminated. A third way was if the subject matter is destroyed. If I crash my Porsche in a fiery accident on University Avenue after class, that terminates my offer to sell it to her. She cannot come in the next day and say, I will buy your Porsche for $10,000, which she wouldn't do anyway since it is destroyed. But destruction of the subject matter terminates an offer. There is one way that an offer can't be terminated in a certain amount of time, and that is called an option. It's in the situation of an option contract. So if I tell Miss Alderman I offer to sell you my Porsche for $10,000, and my offer stays open until noon on next Friday. But in order for me to keep that offer open till noon on next Friday, you got to give me $100. If she does that, then I can't terminate that offer before next Friday. Those are option contracts, and we see those in real estate a lot of the time, where if one party wants time to think about it or do some due diligence, or see if they can raise the money, or, because they're having a hard time making a decision, they could pay the offeror to leave the offer open. If that happens, that's an option contract. And what that really means is Ms. Alderman has the option to accept my offer until next Friday. Now, if she had not paid me anything for that, and I said, hey, I'll sell you my Porsche for $10,000, you got to let me know, leave my offer open until next Friday at noon. But she doesn't give me anything of value so that she can hold the option on it, then I can call her up Monday and say, hey, I've terminated my offer. That's okay. So just because I say that I'm going to leave it open for a certain amount of time, that doesn't mean that I have to do that. I only have to do that if she's given me something of value to protect her right to accept my offer within a certain amount of time. Does that make sense? I just totally skipped over that on Tuesday, and I apologize. All right, let's get into the cases of Lucy versus Zemer and Wright versus Newman. Who wants to give me the background on Lucy versus Zemer? Who are these guys, and how did they come to have a dispute? Who wants to do that? This is the part where everybody looks down their computer. Nobody?
Is that the case about where the napkin and they signed?
That is that case.
Farmland that was 50
Yep.
million?
Who is Mr. Lucy and Mr. Zemer?
I want to say when I was reading the case, I think the Zemers were the ones that owned the land.
That's right. Mr. Zemer owned the land. What was the name of the land? The Ferguson Farm. Thank you, April. The Ferguson Farm. So how did this deal come to be? Who remembers? Is anybody going to give us recount the details of the Saturday night at the motor court before Christmas? We went Saturday night, December before Christmas. Is that right? All right. So Zemer owns the bar, right, or the restaurant / bar, and Mr. Lucy and Mr. Zemer are acquaintances. They know each other, and Mr. Lucy comes in carrying what with him? Whiskey. A half a bottle of whiskey. That's right. Good, Dalton. And so these two had talked about buying the Ferguson farm or selling the Ferguson farm before. Mr. Lucy had made several offers. The parties both testified that they had discussed it many times over the years, and that Mr. Zemer always said, I'm not selling the farm. But on this night, Mr. Lucy says to Zemer, I bet you wouldn't sell me the Ferguson farm for $50,000. Now, based on what we know about offers, is that an offer to buy the farm for $50,000? He just says, I bet you wouldn't do it. I mean, that's not a clear, definite offer. And so in response to that, Zemer says, you don't have $50,000. You couldn't buy it even if I would. And Mr. Lucy says, bet. Put it in writing. So after, according to the parties, a night of drinking, or in Mr. Zemer's case, he'd been drinking all day because it was the holiday season, and I think it was on the weekend. So Mr. Zemer, what does Mr. Zemer put on paper? Well, what kind of paper does he write it on? That's right, a napkin at his restaurant. And what did he write down? Just what's the gist of it?
He agrees to sell the farm.
Right. I will sell the farm to Mr. Lucy for $50,000, the Ferguson farm for $50,000. And then Mr. Lucy says, there's a problem with what you wrote. What was that?
You need to change I to we.
Right, you need to change I to we, because Mr. Zemer owned the farm with his wife. So Mr. Zemer does that. Then what does Mr. Zimmer go get? He gets his wife to sign the napkin as well. So, and then it gets conflicting a little bit in their testimonies, but they seem to agree that Mr. Zimmer put the napkin down. Lucy snatched it and put it in his pocket and says, "We got a deal." And Mr. Lucy proceeds to have the title examined on the following Monday, and then writes Mr. Zimmer and says, "Okay, the title checked out. I'm ready to close. When would you like to close?" And Zimmer says, "We're not closing. That was all a joke. I never intended to sell you the farm. We were drinking. You know, I've always said I will never sell the farm. There's no way that you could have seriously thought that I intended to sell the farm." So that's the backdrop to where we are. Well, at the trial court level, when Mr. Lucy sued Zimmer to make him follow through on what he believed was a contract, the trial court found for Mr. Zimmer and said, "Zimmer wins. You guys didn't really have a contract for the sale of land." But Lucy appealed to the Supreme Court of Appeals in Virginia. This is in 1954. So the opinion that you read is the Supreme Court of Virginia's review of the case, and they overturn the trial court, and they say, actually, you did have a contract, and Zimmer does have to sell the land to Lucy. And the reason for that is that the court applies what we talked about Tuesday, the objective theory of contracts. A court will not look at what you might have meant, what you were thinking in your mind, what your intent was subjectively. A court is not a mind reader. They're only going to look at what your outward actions, words, body language, what your outward intentions were. And then they're going to say, based on those, what would a reasonable person have expected? What would a reasonable person say? So, there's arguments, pretty good arguments, on both sides of this. On Lucy's side, let's throw out what were some of the best arguments that Lucy had? I don't mean arguments, so let me say it a different way. What were some of the facts that were on Lucy's side? I'll start. They talked about it all night long. They weren't passing on the street corner in downtown Columbus. "Hey, I'll give you $50,000 for that farm. You don't have $50,000. Ha ha. Put your money where your mouth is." They discussed it all night long. That's one good fact for Lucy. What's another one?
I got a question.
Yes, sir.
Did they meet to talk about the farm?
Did they meet to talk about it?
Yeah.
Where? Oh, was that their purpose of meeting? It was not. So that might be a fact for Zimmer, right? If they met at a real estate office or something like that, maybe that was different. I'm going to ask you in a minute to change some facts that might be better for either. So that's a good question. The court that says that Lucy we don't know. Lucy could have gone in there thinking, I'm going to try to get Zimmer liquored up and get him to agree to sell me the farm, but the case doesn't give us those facts. George. His wife signed it, right? If he was joking, why did he go get his wife to sign it? So that's a good fact for Lucy. He changed it from I to we. If he was joking, why did he go through all this trouble to change it? What about who wrote it? Who wrote the contract? Who wrote the thing on the napkin? Which one of the parties wrote it down?
It was Zimmer's, because he had to give it back to his wife.
Yeah, Zimmer's the one that wrote it. That's a good fact for Lucy. I didn't write it. It's not like I wrote it down and now I'm trying to make him, I'm trying to bind him to something that I wrote. He wrote it. I didn't force him to write it. Nobody forced him to write it and sign it. What's another good fact for Lucy? What was the farm worth? Y'all remember what Mr. Zemer bought it for and what it was, the tax value was? Say that again, April.
11,000, the taxes were like 6.
Yeah, he bought it for 11,000, tax for like 6, and he sold it for 50. That doesn't suggest a joke right there, does it? So those are all good facts for Lucy. There's some good facts for Zemer too. What were the good facts for Zemer?
Lucy brought in some alcohol for Zemer to drink.
Lucy brought in the alcohol and was pushing it on Zemer, right? Zemer didn't say no. And nobody twisted his arm. And in fact, Zemer even said, he put the ball in front of me and I knew better, but I poured myself a slug anyway. He was feeling right. So that's a good fact for Zemer. Look, he's a shark. He came in my bar, in my restaurant, and pushed liquor on me. He brought it up. I never said anything about the Ferguson farm. What's another good fact for Mr. Zemer?
But then also, it was kind of like brought up as a joke. I bet you I could buy your farm from you. So it's kind of hard to take somebody seriously. Of course, when you're intoxicated too.
That's right, Stevon, because that's an argument I would make is, look, we were bullshitting all night long. We spent 3 hours, and they both agreed, and some of the witnesses said the gist of it was that they were really arguing about whether or not Lucy could come up with $50,000. You can't come up with $50,000. And Zemer was like, I just did that to call his bluff. I wanted to embarrass him. I wanted to prove that he couldn't come up with $50,000. That was absurd. That's a good fact for Mr. Zemer. Christian brought up a good one. They're in a bar. Is that where we generally do real estate deals? Is that where we generally go to do serious business? I think the court calls it a serious business deal or something at some point, which is kind of funny. So there are good arguments on both sides. One of the good arguments for Lucy that we didn't talk about was Zemer said, I told my wife this was a joke, but I didn't say it loud enough for Lucy to hear on purpose. Well, if this was a joke, right, this is one of our takeaways. If you're joking, you better damn sure say you're joking. Because look what happened. This guy ended up getting stuck selling a farm that he really probably didn't want to sell. So this is an example of the court applying the objective theory of contracts. We're only going to go by what a reasonable person could have interpreted your objective actions, words, and writings to mean. So you can see that, this went before 2 courts. The trial court heard all the witnesses, saw the people testifying, and found for Zemer. The appeals court read the record of the transcript and found for Lucy. So these cases are not, most of the cases that go to court are not black and white, and they're not cut and dried. 2 courts full of judges who presumably are, good at what they do, or they wouldn't be judges, saw the same facts and came to different conclusions. So we can argue both sides of that very realistically and convincingly. Yes, ma'am.
So he had offered to sell the farm at first, like already to Lucy, like a couple years back.
I think the case said that Lucy had made offers to him.
But he said he backed out of the offer. He offered.
Mr. Zemer never agreed to any of Mr. Lucy's earlier offers through the years. And Mr. Zemer said in his testimony, I've always made it clear that I don't want to sell the farm. I want to give it to my son. Everybody knows that I've always said I'm not going to sell the farm. But objectively, everybody knows that's not objective. The objective facts were he wrote it down. He got his wife to sign it. He made changes to it. He was the one that wrote it. They discussed it all night. And the court it says, based on those objective facts, we could conclude that that is a serious business deal. Now, again, on the other side, we were drinking, we were BSing. Mr. Lucy should have known through the years that I don't intend to do this. Most of our discussion was whether or not he even had $50,000. Anybody who was sitting at the bar that night would have listened to us and concluded that we were not in a serious business deal. You can argue both sides of it. Probably best takeaway is don't contractually obligate to anything on a cocktail napkin at a bar. Right? Sounds simple, but these gentlemen found themselves in court over that. All right. Moving on to the Wright versus Newman case. This is a Georgia case from the 90s, and it involves the idea of promissory estoppel. And just because we're running out of time, I'm going to summarize it for you here as fast as I can. Wright and Newman were married. And Mrs. Newman had 2 children, a daughter that was Wright's daughter, biological daughter, and a son who was not Wright's biological son. And both Wright and Newman knew that the son was not Wright's, okay? But they were married, and Mr. Wright, maybe they weren't married, but Mr. Wright signed the birth certificate. Mr. Wright gave the son his last name. Mr. Wright parented the child with Miss Newman up until the child was around 3 years old, at which point Wright and Newman broke up. And for, I think, a 7-year period, Mr. Wright didn't have much to do with the child. But around the time the child was 10, the son was 10, Mr. Wright became involved in his life again. And at that point, Mrs. Newman sued Mr. Wright for child support. And so, yeah, they weren't ever married, because if they were in their divorce, child support would have been dealt with then. So they were never married. So Miss Newman sues Mr. Wright for child support. And they don't have a contract in the sense that Mr. Wright never said to Ms. Newman, I will pay you child support. He supported the child, but they didn't have that explicit promise. But even if he had said, I promise to pay you child support, there's a promise on his part, but there's no consideration coming back from Ms. Newman in return for that. So we don't have consideration. So how can we establish a contract when there's no consideration? We could use promissory estoppel as a substitute for consideration. And that's what the court does here. The court says, yeah, there isn't consideration, but Mr. Wright, when you put your name on this child's birth certificate, when you gave him your name, when you parented him for 3 years, you made the promise. You undertook the obligation to support this child. And we're now going to say that there was consideration in the form of promissory estoppel. Well, let's go back and think about the elements of promissory estoppel for a second. I mean, one of the elements is, did Mr. Wright make a clear and definite promise? Not really. I mean, you can't find anywhere where he wrote down or said, I'm going to support the child. The court is inferring the clear and definite promise from his actions and putting his name on the birth certificate and giving the child his name and supporting him for 3 years. Ms. Daniels.
I was just gonna say, didn't he make himself legally obligated, so that was like part of consideration once he put his name and actually?
So that's a good question. Under Georgia law, just being on the birth certificate does not legally obligate you to anything. It actually doesn't even make you, you don't have legal rights to a child just because your name's on the birth certificate if you're not married. If you're married, then that child is legally yours whether or not you're the biological father or not. This is Georgia law. As long as you're married and your wife has a baby, doesn't matter whether you're the dad or not, that's legally your child. But they were not married. And so him just putting his name on the birth certificate didn't come with any legal obligations. If it did, then this case would never have gotten to where we were. But that's a good question. So was it reasonable that Mr. Wright would have expected Miss Newman to rely on his promise, such as it were? Was it reasonable for her to rely on the fact that he gave the child his name, he's on the birth certificate, he supported him for 3 years, he held this child out as his own? Was it reasonable at that point for her to believe that he was undertaking to support the child for the rest of the child's minority? The court disagrees on that. The majority opinion says, yeah, it was reasonable for her. Did she rely on it? And was that reliance reasonable? This is where the court disagrees. So the majority opinion says, yeah, she relied on it because she didn't go and seek child support from the biological father. She didn't go and seek to establish the parental relationship between the son and his bio dad. She did rely on it because she didn't do any of those things. And the court says it was reasonable for her to not do that because, look, she had a man that did all these things and parented the child for 3 years. What expectation did she have that he was going to stop? And at that point, it was too late. That's the majority opinion's deal. Justice Benham wrote the dissenting opinion, and he said it was not necessarily reasonable for her. She waited until the child was 10 to sue Mr. Wright for child support. She left him when the child was 3. There's no evidence in the record of what she did during those 7 years. There's no evidence that she tried to go after the bio dad and was unsuccessful. So we don't know what her detriment is. And Justice Benham is really saying she could have relied on her detriment. He just didn't see any evidence that she did, that they didn't put any evidence in on the trial court that she had been unable to collect from the bio dad or things like that. His problem was just that the record was not complete or full of any evidence to that effect. But Justice Sears wrote a concurring opinion that directly rebuts Justice Benham because she didn't like what Benham said. And she was very strong and said, look, society is better off when we hold fathers to their obligations to support children. And if we didn't do this, it would result in all this harm to the son and so on and so forth. And so there was some sparring going back and forth between them. But this is a real life case of promissory estoppel. So again, we didn't have a contract between Wright and Newman because there was no consideration going back from Ms. Newman to Mr. Wright. No contract. But promissory estoppel can be a substitute for consideration. And so that's what the court does here. It says you didn't have a contract because there's no consideration, but we're going to find that there was consideration in the form of promissory estoppel because Mr. Wright made a promise through his actions. She relied on it. It was reasonable for her to rely on it. She relied on it to her detriment. And fairness dictates that we need to find that there was a valid contract here. So that's a real life example of how promissory estoppel works. Any questions on that? Okay, so I will see you guys. Don't leave yet. I need to get roll, but also those of you who came in late, please be on time Tuesday, and please come. I want to have a full class for our speaker, and I am going to give you an assignment based on some of the things he says. So I do need you to come and be prepared to listen and ask questions.